Congress just passed nationwide legislation blocking Suppressor and SBR tax restrictions, and the registry block is now being pushed through. Hit subscribe right now, because what the media isn't telling you about this bill will completely change how you see federal gun control. The $200 distraction. The $200 NFA tax stamp was introduced in 1934, and when you adjust for inflation, that fee would be about $4,000 today. Back then, a Thompson submachine gun cost the same as that tax stamp, which means the government deliberately priced the tax to make ownership prohibitively expensive for average Americans. Fast forward to today, and that same $200 barely covers a quality optic, yet it remains the focal point of every conversation about NFA reform. But here's what nobody mentions in those debates. The tax generates roughly $40 million annually for the ATF, which sounds significant until you realize the agency's total budget exceeds $1.5 billion. That tax revenue represents less than 3% of their operating budget. Every Form 4 submitted does not just collect a fee. It collects your name, your address, your social security number, your fingerprints, 2 passport photos, and a detailed description of the exact item you are purchasing, including make, model, caliber, and serial number. The legislation eliminating this tax is not about giving you $200 back. It is about cutting off the information pipeline that has been feeding a federal gun registry for 9 decades. And that brings us to something the media refuses to discuss: what the registry actually contains. The National Firearms Registration and Transfer Record is not just a list of serial numbers. It is a comprehensive database containing over 5.8 million records as of last year, with 2.6 million of those being suppressors alone. The ATF maintains this database under Title 26 of the United States Code. And unlike the prohibited background check registry under NICS, this NFA registry is completely legal and explicitly authorized by federal law. Each record includes the registrant's full legal name, current residential address, place of birth, date of birth, social security number, FBI fingerprint classification, and 2 recent photographs suitable for identification purposes. The database also contains the complete chain of custody for every NFA item ever transferred legally since 1934. Here is where it gets more invasive. When you submit a Form 4, you also provide your Chief Law Enforcement Officer notification, which means your local police chief or sheriff receives a copy of your application. While they cannot legally deny your application anymore thanks to the 2016 rule change, they still receive notification of exactly what you are trying to purchase. According to ATF trace data, suppressors and SBRs combined account for less than 0.03% of firearms traced in criminal investigations annually, yet the registry persists and grows, and those numbers should terrify anyone paying attention. The explosion nobody saw coming. In 2008, there were 400,000 suppressors registered in the entire United States. By 2015, that number had grown to 792,000. Today, it exceeds 2.6 million, which represents a 550% increase in just 15 years. The suppressor market is now growing at roughly 200,000 new registrations per year, and that rate has been accelerating since 2020. The SBR numbers tell a similar story. Short-barreled rifles accounted for 610,000 registrations in 2021, up from just 150,000 in 2012. The ATF's own annual reports show that NFA registration applications have increased by an average of 18% year over year for the past decade. At current growth rates, the NFA registry will contain over 4 million suppressor records alone by 2027, and over 10 million total NFA items by 2030. But here is what makes those numbers politically dangerous for gun owners. Every single one of those registrations represents a name and address in a federal database that can be searched, sorted, and cross-referenced with other government records. When politicians propose mandatory buyback programs or enhanced regulation of gun owners, they are not talking about theoretical lists. They are talking about using databases that already exist, and the NFA Registry is the most detailed firearms database the federal government legally maintains. The legislation blocking tax restrictions does not just save you money on future purchases. It stops the registry from reaching critical mass. Once a database contains detailed information on 10 million gun owners with specific items listed, it becomes a political tool that can be weaponized during the next crisis or the next administration. The media wants you focused on the tax savings because that is a partisan economic argument. They do not want you thinking about database elimination because that is a civil liberties argument that crosses party lines. And that makes it far more dangerous to their agenda. So let me ask you this. Do you think the registry size matters more than the tax cost? And should Congress have prioritized database elimination from the beginning? Drop your answer in the comments. How the rest of the world handles this. Finland treats suppressors as mandatory safety equipment for hunters, and you can purchase them over the counter at sporting goods stores, with the same paperwork required for buying the firearm itself. Norway requires suppressors for certain types of hunting to protect wildlife from noise pollution and prevent hearing damage to hunters. In France, suppressors are legally classified as firearm accessories and are available to anyone with a valid hunting or sport shooting license. No special registration required beyond the initial license application. The United Kingdom, despite having some of the strictest gun laws in the world, actively encourages suppressor use. British law considers suppressors a courtesy to neighbors and wildlife, and they are easier to obtain than the firearms themselves. New Zealand removed suppressors from their restricted items list entirely in 2007, and they are now sold as unregulated accessories in hardware stores, alongside hearing protection and safety glasses. Even Canada, which banned handguns in many jurisdictions and maintains strict firearms control, does not register suppressors separately. If you own the firearm legally, you can attach a suppressor without additional paperwork or federal notification. The international comparison reveals something American gun control advocates refuse to acknowledge. Countries with far stricter gun laws than the United States do not treat suppressors as dangerous weapons requiring federal databases and biometric tracking. And that backlog reveals the real purpose of the NFA process: the deliberate slowdown. The average ATF Form 4 processing time in 2023 was 274 days for paper applications and 112 days for electronic submissions through the e-form system. That means the average American waited 9 months to take possession of a suppressor they already purchased and paid for. During peak periods in 2021, paper Form 4 applications took over 400 days to process, which is longer than most human pregnancies. The ATF claims processing delays are caused by staffing shortages and increased application volume, but their own budget documents contradict that excuse. The NFA division received a budget increase of $12 million between 2019 and 2022, specifically to hire additional examiners and upgrade processing systems. Despite that investment, processing times increased during the same period. Here is what the ATF does not advertise. Each Form 4 application undergoes a full FBI background check, even though the applicant already passed a background check to purchase the firearm the suppressor attaches to. The NFA process requires a third redundant background check that searches the same databases using the same criteria, yet somehow takes 9 months to complete what gun stores accomplish in 90 seconds. The delays are not a bug in the system. They are a feature designed to discourage applications through bureaucratic friction. Which brings us to the question of what individual states plan to do about it. The state-level counterattack. California, New York, Massachusetts, Illinois, and New Jersey have already indicated they will not honor federal NFA tax elimination if it passes. These states maintain their own suppressor bans under state law, which means even if federal restrictions disappear, residents of those states still face criminal charges for possession. California Penal Code Section 33,410 explicitly prohibits suppressor possession, with penalties up to 3 years in state prison and $10,000 fines. But the state-level response goes beyond just maintaining existing bans. Washington State introduced legislation in early 2024 that would require state-level registration of all NFA items even if federal registration ends. The proposed law would create a Washington State NFA database mirroring the federal system, complete with fees, waiting periods, and background checks administered by the State Patrol. Similar proposals are being drafted in Oregon, Colorado, and Maryland. Illinois took a different approach with their Firearms Restraining Order Law, which specifically includes NFA items in the categories of firearms subject to immediate seizure under red flag provisions. Cook County went further by requiring separate county-level registration for NFA items in addition to state and federal requirements. Violating the county registration requirement is a misdemeanor carrying up to 1 year in jail, which means Chicago area residents face 3 separate registration systems for a single suppressor. The pattern is clear. Blue states are preparing to replace federal NFA registration with state-level systems that could be even more restrictive than what currently exists. They cannot stop Congress from eliminating the federal tax, but they can create 50 different state-level taxes, registries, and approval processes that fragment the national market. A suppressor legal in Wyoming could require registration in Colorado, be completely banned in California, and face additional taxation in Oregon. The victory at the federal level could fracture into 50 separate battles at the state level, each requiring its own legislation, court challenges, and enforcement mechanisms. So here is my question for you. If your state creates its own NFA registry after the federal one is eliminated, does that make the federal victory meaningless? And should gun rights organizations be focusing on state legislatures instead of Congress? Let me know in the comments. Why items never return to databases. Once suppressors leave federal registration requirements, there is no practical mechanism to bring them back without creating a completely new enforcement infrastructure. Consider what would be required. Congress would need to pass new legislation making previously unregistered suppressors illegal. The ATF would need to issue a grace period for registration. Manufacturers would need to report all sales during the unregistered period, and millions of gun owners would need to voluntarily register items they legally purchased without registration. The last time Congress tried something similar was the 1994 assault weapons ban, which grandfathered existing weapons but banned new production. Compliance estimates for registration of pre-ban items ranged from 5 to 15% in states that required it. New York's SAFE Act saw similar results, with estimates suggesting 80 to 90% of affected gun owners simply ignored the registration requirement. Here is why suppressor re-registration would fail even harder. A suppressor is a metal tube that looks like a flashlight or a car part to anyone who does not know firearms. You can store a dozen suppressors in a shoebox. They have no moving parts that wear out or require maintenance records. The one-way door is not a metaphor. It is a practical reality based on compliance history and enforcement limitations. But that door only matters if you understand where it leads. What happens when confiscation is impossible? Gun control advocates frequently propose mandatory buyback programs modeled after Australia's 1996 National Firearms Agreement, which collected approximately 650,000 firearms from Australian gun owners. Politicians cite that program as proof that large-scale confiscation can work in modern democracies. But Australia had something the United States would lack if suppressor registration ends: a comprehensive registry of who owned what. Australia's firearms registry was already in place before the 1996 buyback. The government knew exactly which gun owners possessed newly prohibited items because licensing and registration were mandatory for decades. Compliance in Australia reached an estimated 60%, which sounds successful until you realize that 40% of affected gun owners ignored the mandatory buyback despite knowing the government had their information on file. The numbers become impossible. If Congress eliminated suppressor registration and 10 million suppressors were sold over the next decade with no federal records, any future confiscation program would be operating blind. Registry elimination does not just protect current gun owners. It makes future gun control legislation practically unenforceable, and that shifts the entire political calculation for what legislation is worth proposing. But making confiscation impossible only matters if you understand the timeline for when these changes take effect. The timeline to registry collapse. The National Firearms Registration and Transfer Record currently contains 2.6 million suppressor records accumulated over 90 years. At current growth rates of 200,000 new suppressors annually, the registry adds approximately 8% to its total every year. That growth rate has been consistent since 2015 and shows no signs of slowing under current law. If federal registration requirements end, every suppressor purchased after the effective date becomes invisible to federal tracking. Year 1, after elimination, would likely see suppressor sales triple or quadruple as buyers who avoided the NFA process due to registration concerns enter the market. Conservative estimates suggest 600,000 unregistered suppressors sold in the first year. By year 3, unregistered suppressors would outnumber newly registered ones. By year 5, the registry would contain roughly 3 million tracked suppressors, while an estimated 2 million unregistered suppressors exist in civilian hands. Here is where the math becomes devastating for gun control advocates. The registry's usefulness as a policy tool depends on completeness. A database tracking 90% of suppressors is valuable for enforcement. A database tracking 50% is questionable. A database tracking less than 30% is statistically meaningless and politically indefensible. At current projections, the NFA suppressor registry would drop below 50% coverage by 2029 and below 30% by 2032. Once the registry becomes minoritarian, meaning it tracks less than half of existing items, its political utility collapses. You cannot justify enhanced regulation or mandatory programs based on incomplete data. Courts would question enforcement actions based on databases known to be missing the majority of items. And most importantly, gun control advocates would lose their best argument for universal registration because they would be forced to admit their existing registry failed to maintain coverage. The timeline to registry collapse is not theoretical. It is mathematical. And it is why this legislation terrifies gun control organizations more than any other Second Amendment victory in recent memory. So let me ask you one final question. If the registry becomes statistically meaningless by 2032, what do you think gun control advocates will propose to replace it? And are gun owners prepared for that fight? Drop your predictions in the comments below. The registry collapse is already starting, and this is just the beginning. If you want to stay ahead of Second Amendment legislation as it happens, hit that subscribe button and turn on notifications. More breaking gun rights analysis is coming this week. Thanks for watching, and I'll see you in the next one.